G'day, Nick. Good to see you.
Hello, Bowie. Great to be here.
Yeah, we've just moved to the other studio. This is my favourite studio, this one. This is the other one.
Yeah,
This is the Rod Tiley studio.
apparently,
You'll sound better in here.
yeah, apparently brings back memories for you.
It does. Well, this is it was this studio. I think James was with me. We were the first show ever to go in the studio, weren't we?
Yeah.
Who was our
Absolutely.
special guest?
It was Hank B. Marvin.
It has been Marvin. It was. Well done to my encyclopedic colleague James Keys. Now, if you'd like to ring Nick with any of your law questions, you can 133 882. Nick, I'm going to ask you about Slater and Gordon in just a moment. This massive multinational company have had some sort of breach where it seemed there's some sort of prank email that's revealed everyone's salaries. Would you want to know the salaries of the people that you work with? Nick will have some thoughts on that in just a moment. Annabelle's phoned in. Hi, Annabelle.
Hi, how are you going?
Good, thank you. Fire away.
So, hi, Nick. My partner and I built our house back in 2013, and somehow when we purchased the land, we were put into joint tenants rather than tenants in common. We only realised that this year, so we were wondering if we write a will, is that watertight to leave the house to each other, or should we be changing it back to tenants in common?
Okay, so basically, there's two different ways of owning property together, and as you've identified, there's joint tenancy and tenants in common. So joint tenancy means that there's something called a right of survivorship, which means that if someone dies, the other person automatically inherits the property, no matter what's in the will, no matter anything else, right? It's very common between spouses. If you have it as tenants in common, then you can actually distribute your share of the property, say your 50% property, in your will. So if you want it to go automatically to your husband and vice versa, without any complications, you should have it as joint tenants. If you want it to, tenants in common is often used with family members. Siblings may buy a property together. If they buy it in unequal shares, then that's probably appropriate, and then you can distribute your 50% share in your will to someone else. So I would suggest joint tenants, because if that's what you're after, Annabelle.
So, sorry, I thought it was the other way round. I thought joint tenants was the one where you had it yourself, and tenants in common was where it went into. So what my question is if we write a will, whichever one we are, which I'm not sure now, but the one we are means that it's going into our estate. It's not going directly to each other. So if we write a will, is that watertight in the future, or should we change it to the one that's automatic survivorship?
So the will is generally pretty good. The downside of a will is that it can be challenged. So if it's tenants in common, so I think it sounds like you just confused them. But if it's tenants in common, then say if you have someone challenges your will, which is only a limited amount of people, parents, children, grandchildren, certain circumstances, then they can challenge the will. So it's not completely watertight. The most watertight one is joint tenants, because that automatically goes to your spouse. So that will give you 100% comfort, but a will does most of the job.
But you'd recommend changing it to joint tenants?
I mean, yeah, if you can, you should. Especially, I don't think there's any stamp duty involved, because there's no change of beneficiary owner. So if you could, but a will is still pretty good. And if you as long as you're not leaving kids out of the will or anything like that, then it's probably unlikely your will is challenged.
Okay, and online wills are good.
Yeah, absolutely. You have to just get it signed. Online wills, good reputable ones are fine. But just make sure you sign it. Perfect. Keep the original. Yeah, witnessed by two people.
That's great. Thank you so much for your help.
Thanks, Annabelle. Thanks for calling in. Nick Maruchak from MKI Legal with us today, answering your legal questions. 20 minutes to 11 o'clock. G'day, Mark.
G'day, boys. How are you going?
Going well, mate.
The question I put to the producer is that a boat was purchased in the name of in the sole name of a person. That person paid for the boat, and that person insured the boat, fully paid by him. The person also pays the pen fees for the boat, fully by him. So the pen fees contract with DOT is in his name. The insurance is in his name solely, and so is the contract of sale for the boat. The boat is registered with the DOT, except they have a primary owner, which is the person who purchased the boat, and two secondary owners are named, two persons known to the primary owner. The two secondary persons are claiming an interest in the boat to a third value. And I'm wondering whether the mere presence of the declaration or the registration bestows a proprietary interest on the two other persons, given that the boat was purchased by the purchaser.
Yep.
Fully.
So how did
all costs have been...
Margaret Simon, how did the secondary names get on the document in the first place? What's the relationship there?
They were placed on there by agreement by all three parties.
Okay.
In case there was an event at sea, because they all used the boat.
Yes.
One hasn't used the boat since 2020.
Yep.
But it was without legal advice, they had thought, let's put all names on. So if there's an event at sea, even a death, there's a duly registered person.
Gotcha.
Because they don't sail together; they sail differently.
So now at the point of sale, the other two are saying, well, we have an interest in this because our name's on the document. What do you think, Nick? Do you need to go away and think about this, or?
I can give a kind of an answer, right? So when someone's name is on the title or someone's name is not on the title, there is in equity, right? Equity is this law that kind of comes in to help us out if the strict black letter of the law doesn't quite work. So something called constructive trust. So if someone contributes to a property, like in this case, the owner paid everything, the other people didn't pay anything. So even if they have a legal interest on the title, the person that paid for everything can probably make out an argument in constructive trust to say, well, you're holding your share on trust for me because I paid for everything and you didn't contribute anything. So that's probably an argument you can make here.
Yep.
And I'll probably see a property lawyer on that. If they are it also depends on the agreement as well, right? So there obviously is some discussions there, but that's the primary thing. The constructive trust. Another alternative argument is a resulting trust. And the purpose of these two things is basically to stop inequitable, unfair circumstances like this. And it could work the other way. So if someone's name is solely on the title and you pitched into the purchase of the property, you can claim an interest as constructive trustee as well, even though your name is not on the title. So it works both ways.
Does that help, Mark?
Got it. Yep, that does help. That's very good. Thank you very much.
Cheers, mate. Thanks for ringing. Natalie, stay there. We'll come back in just a moment. This Slater and Gordon email scandal where everyone's salary's been revealed, courtesy of a dodgy email. We'll talk to Nick about that. And Natalie, we'll talk to you in just a moment about your joint tenancy question as well. 16 minutes to 11 o'clock. This is Nick Maruchak from MKI Legal. And Nick Maruchak's with us as well. Nick attended the launch of the 6PR calendar year. All the presenters and all the footy boys and girls were there. It's quite the afternoon, wasn't it, Nick?
It was a lot of fun. Jacko was going crazy. He was very entertaining.
He was fired up, wasn't he?
Yeah. Well, my business partner was there, and he just guessed someone's a footy statistic, and he won a signed ball. So it was pretty fun.
Look, I think fair to say Glenn Jakovich has built up a real head of steam about this football season. So make sure you listen to our number one call team for the 5 games they will broadcast this year, each and every footy weekend. Natalie, how are you? Nick's here.
Hi, Simon and Nick. Annabelle's query about joint tenancy versus tenancy in common brought to mind a conversation I had with my mum last week. She has quite a sizable estate, which she's left to be divided between my brother and I. And she was wondering if she needs to rewrite her will or update it because she was concerned that should I predecease her or die before probate, she wanted my 50% share to go to my children and not to my brother, and she's not with any malice intended, but because she wants to look after her grandchildren. And she was asking me, does she need to stipulate in her will that my brother and I would be tenants in common, or is there another way that she could ensure that my kids get my share if I'm not around to pick it up myself?
Yep. So the best way to do it is when you write the will, you basically put an express provision in the will to say if you or your brother passes away first, leaving children, then each of your share goes to each of your children. So that's the best way of doing it. Tenants in common and joint tenancy is not really It's not really relevant for the wills. It's really relevant when the actual house goes in your name. So then that's when you decide how you want the ownership to happen. So you would write a will saying, I leave it to my 2 children, John and Sally. Sally passes away first. It goes to her kids and vice versa. And if they don't have any children, then the surviving child gets it. There's also, if your mum doesn't have that, there is a backup provision dealing with this because it's such a common issue in the Wills Act that talks about if a parent passes away, it goes to their children first. But I'd recommend your mum drafts a will to expressly state that in her will to avoid any confusion.
Okay, thank you.
Yeah. Thanks, Natalie. Thanks for calling in. It's coming up 10 minutes to 11. G'day, Richard. How can we help?
G'day, Simon. I got a question for the lawyer. It's about interning during power of attorneys. Right, my parents are getting quite forgetful, and unfortunately, as they're getting older. And how long is too long to wait for a power of attorney? Because they sort of want to do one now because they need help with their banking and all that sort of stuff. And obviously, I can't until get a power of attorney. How long is too long to wait?
So you're concerned that your parents might be might have some sort of cognitive issue. That it's a question.
Yes, they're definitely not 100%. If you get my drift.
Yeah. All right. So your options are this. Best case is you go to a doctor, you get a letter from a doctor. The doctor reviews them, interviews them, and writes a letter to say yep, or a report to say they have the ability to sign a power of attorney. That will cover you. Once you got that, you go to a lawyer, and lawyer will draft it. Later, if anyone challenges you to try to set it aside and stuff like that, you have the letter. If the doctor says nope, they can't sign a power of attorney, they can't do it, they don't have the mental capacity, then you have to go to the State Administrative Tribunal and you have to apply for an order to become administrator, and all the other kind of interested people in the family have a chance to have their say, and then the SAT will appoint you or whoever else as the administrator. So, it's really the medical advice you have to get. Does that help?
Well, that does. That helps a lot. Cool. I thank you very much for the information. It's just getting quite stressful.
Oh yeah, absolutely. Can imagine. And in an ideal world, we address enduring power of attorney prior to people getting sick, don't we? Before there is a cognitive decline, but sometimes it happens and it comes out of the blue and we're not ready. Thanks, Richard. Well answered, Nick. Thank you. G'day, Luke.
Yeah, hey guys. My question's about defamation. If I was hypothetically accused of theft or assault, would I be required to prove my innocence in being accused of defamation or something like that?
In what context, Luke? Hypothetically, in what context? Is it at work or a civil matter? What is it?
I guess you could say a civil matter. Yep.
Okay, so defamation, you have 12 months to commence a claim. Very, very tight. It's in the Supreme Court. The first question that we always ask in defamation is, did you do it, right? So if you say, nope, I didn't steal, then it goes on to the other person to actually to run a defense. And their defense will be contextual truth. They will say he did do it, right? So that's one defense. If he can prove that, it's up to him to prove that you did do it on the balance of probability. And if they can prove that, then you won't win. But if they can't prove it, then you get up. There's also a number of other defenses as well. One defense is qualified privilege. So if you say something defamatory to someone who has an interest in hearing the subject matter, that's a complete defense. So it also matters how this accusation happened, right? If it happened just, your employer wrote to you and privately, then it might be difficult to do defamation, right? But if they did it publicly or if they did it unreasonably, then you might have a case. So if you want to expand on that, I can. Otherwise, probably good to see a defamation lawyer. Because there is a number of defenses. Defamation claims can be expensive. Sometimes you don't get a lot of money out of them. Sometimes you do, depends on your losses, and you have to act quick. And the first thing you want to do is write a concerns notice to them. It's a procedure in the Defamation Act.
There, Luke. I hope that helped, mate. Thank you. Good luck with it all, whatever it is, hypothetically. 7.5 minutes to 11 o'clock. G'day, Trev.
Hey, how you going?
Good, mate.
I purchased the vehicle, it was 12 months ago, but I've had to get something repaired on the instrument panel, and then I find out basically the instrument panel's out of a 2-year newer vehicle than the vehicle that I purchased. So I had some questions about the odometer reading, and which it's a completely different vehicle. So I spoke to the people I bought the car off, and they just said, "Oh yeah, no, you bought the car. That's it. Tough cheese." So I'm actually going to get a ECU reading, which will give me the actual kilometres of the vehicle. I just wondered where I stand. Like tampering with an odometer is a $50,000 fine.
Yeah, it's illegal. Yeah. It's illegal. People have been done for that. So, who'd you buy it off? Did you buy it off a business? Did you buy it off an individual?
It was a rather large, big auctioneer who does a lot of big machinery auctions and vehicles and stuff. Yeah, one of the biggest around. And the general manager sent me an email and said, "Oh no, basically, you can bash it. We don't need nothing from our end." Yeah.
Well, so when it comes to Australian consumer law, that's what applies here. But there are some exceptions for auctions. So when you buy something from auctions, they can get out of things, right? So all they have to do is they have to kind of give you title to the product, but they don't have to have this overarching responsibility to make sure that the good is fit for purpose and merchantable quality. So that is the complication in your case, right? Where because of the auction, there is some exceptions they can rely on. If you bought it from a dealer, if you bought it, then Australian consumer law would apply. But I would report it to Department of Commerce, Department of Transport, because it is illegal, right? So someone committed a crime there. They can see if they can investigate it, find out how that happened, and potentially just see a lawyer about that to see if there's anything else you can go against the auctioneer there, because they do have some carve-outs.
Yeah. Trev, let us know how you go, mate. Keep us posted, and Nick will be back next week, and perhaps we can follow up if need be. We didn't get to Slater and Gordon today, Nick. We've run out of time, but we will get to that at another time. Mate, thank you for coming today.
Thank you, Bob.
Thanks for talking to our listeners, and we look forward to seeing you next week. Have a good day.
Thank you.
Cheers, Nick Maruchak from MKI Legal. 4 minutes to 11. We'll take a break. When we come back after the news, Mick Collis will be in the studio.